Hi everyone. So in today's log installment, I will be discussing two topics and how they are linked. The first one will be the presumption of innocence, and the second one will be forensic investigative genetic genealogy, or FIGG, and how that specifically relates to the state of Idaho versus the Bryan Kohberger case. The presumption of innocence is something that we like to pay lip service to, and yet it doesn't really seem to have permeated into our collective consciousness, as it were. Go to any true crime comment section, and you'll soon see that we all love a good digital stoning. And I don't see it being front of mind with law enforcement. And I don't see much evidence of it being the prevailing belief in the court system, especially when you consider just how grotesquely uneven the playing field is. Commonwealth resources always dwarf that of the average citizen, with defendants often struggling to afford the most appropriate counsel, pay for expensive lab tests, and then, of course, to get the experts to interpret those lab tests. And the status quo is obviously just fine with everyone because we rarely see a challenge to the state's ever more brazen power grabs, nor do we have the courage to even admit that there might be an issue with that dynamic. And it's worth noting that Thomas Hobbes back in the 1600s described his perfect government as the Leviathan. And while he may not have used that term as a pejorative, it was nonetheless a beast of immense power and of overwhelming control. So it's my position that the shunting of one of our core democratic principles in the name of expediency or for the greater good doesn't lead to enhanced justice for victims and their families, and it certainly doesn't make us safer. Safety comes from building cohesive communities, not ever more invasive technology. And that brings me to the second topic of this vlog, which is forensic investigative genetic genealogy and how it's being used in the state of Idaho versus Bryan Kohberger. So firstly, let's just briefly discuss its predecessor, which is STR analysis, or short tandem repeat analysis. STR analysis is where short sequences of DNA form a series at designated sites across the genome. The variability of the lengths of those STRs is what enables comparisons and positive matches when uploaded into a database like CODIS. FIGG analyzes single nucleotide polymorphisms, or SNPs. SNPs are a sequence variation in the genome that differ from at least 1% of the population. Mutations in that sequence are uncommon, so they tend to persist from generation to generation. Now, it's possible to extract in excess of over 600,000 SNPs from one usable source of DNA via something called microarray genotyping. Microarray chips can be acquired for as little as a couple of $100, making them actually a very cost-effective tool for law enforcement. And they are a type of slide that consist of millions of probes that bind to the SNPs, creating a genotype profile. This profile is then, I like to say controversially because it is, this profile is then controversially uploaded into a retail database like GEDmatch or Family Tree DNA, and then genealogists reverse engineer a family tree, thus narrowing down potential suspects. So that's FIGG. And your next question would be, why is Vanessa having a tanty about it? After all, DNA has been used in the courts for well over 30 years now, and no one really seems to have an issue with it. One could even argue that this new methodology will stop serial killers dead in their tracks, Violent crime will come down because the deterrent should be so high. The cold cases are going to be solved. We're going to be able to repatriate unidentified people with their loved ones. So when you put it like that, it all seems positive, right? So why am I being such a killjoy? Well, many people have asked me that. Why am I being such a killjoy? Well, it's not actually the tech here that's the issue. It's the unregulated use of those retail databases that I was talking about. IGG would be absolutely nothing without those databases. This actually happens to be the mother of all privacy issues. And I've actually heard the Idaho versus Kohberger case referred to as being the trial of the century. And to be honest, I don't really think they understand what they're saying, but I don't think they're far off, right? So if you're not up to date with the Kohberger case, the current narrative is that a knife sheath was found in an intimate area of the crime scene, and it was a brutal crime scene, without a doubt. From the said sheath, a usable quantity of single source DNA was acquired, but when it was run through government databases or CODIS, it didn't get any hits. Now, in my opinion, and I know that it's going to seem controversial, that should have been the end of the line for that DNA as far as the investigation goes. Well, now the question is why? What's my rationale for that very controversial opinion? Do I not want to see criminals being brought to justice for their despicable crimes? No, that's not it at all, and it couldn't be any further from the truth. I just want it done correctly. I want it done ethically, and I don't want them reverse engineering investigations to fit a suspect. That's it. That's the short of it. But anyway, let's keep going. Firstly, we have to understand what CODIS is, right? What CODIS is, what it's for, and who's in there. CODIS is the state's apparatus for indexing DNA from crime scenes, okay? So who's in there? Convicted criminals, obviously. In some states, depending on the crime, arrestees, forensic samples, missing persons and their biological relatives, and unidentified remains. So that is a very specific range of individuals. It's a very specific range of DNA profiles, okay? But their one commonality is that they have, for one reason or another, all popped up onto law enforcement's radar. They have, for all intents and purposes, been processed. And it should remain everyone's goal in life never to find oneself being processed by law enforcement, right? Can we all agree on that? So if you're just an average Joe trying to get by, a head down, tail up kind of guy or woman, then you have by default earned the right not to be in one of those databases. You don't belong in there with that riffraff. That is your reward for being normal. Again, if you're a fine, upstanding citizen and you're walking down the street, it is your right not to be harassed by law enforcement. Once again, that's your right. You have earned it. It's your reward for being a normal person. And this is how it goes when you don't live in a police state. You shouldn't be in active combat with a government that is trying to harvest and seize any and all information it can on its citizenry. I genuinely don't know who else needs to be reminded of this, that we live in a liberal democracy and we are obliged to limit government overreach because that beast will never stop coming for you. It is expansionary and coercive by nature. So I ask you, who gave those craven and inept policymakers at GEDmatch and Family Tree DNA the right to enact such widespread and far-reaching social change? And where are our best legal minds challenging the consensus creep we now see happening in the courts? And speaking of the best legal minds, a few months back, there was a hearing to suppress the IGG work in the Kohberger case. And Anne Taylor, who's Bryan Kohberger's attorney, thought she'd give it a crack. So I will basically be reciting what was said at the hearing verbatim. It's accessible on the internet if you'd like to double check, but I'm just choosing the most salient parts. So this is how she kicked it off. Might be needing some glasses. This is how Anne Taylor kicked it off. For the purposes of the Fourth Amendment protections and Article 1, Section 17 of the Idaho Constitution, we are looking to see if somebody has a privacy interest that society is ready to support. In this case, if society is not ready to support suppression of every bit of our DNA when the government does not have a warrant and searches it, there is no privacy left. So here we have Anne Taylor opening up with some really foundational philosophical thoughts about our natural rights regarding our unique genetic markers and whether big government should be allowed to search them whenever and wherever they happen upon them. Now, Hitler doesn't really care for Anne's attempt at creating new law, as it would clearly be an inconvenience if the state were to have diminished control over our DNA and its use. He cuts right to the chase, saying, "It goes to whether or not your client has standing to complain about the searches of the databases, because, as the state has posited, it wasn't his DNA that was searched. It was, at best, his ancestors." And he continues, asking, "I have a privacy interest against any of my relatives that might want to upload their DNA to one of those systems. I should be able to stop them from doing that because I share some DNA with them." So it's pretty evident at this point that Hitler and Anne are speaking past one another. They're on completely different planes. And without sounding disrespectful, it's also quite clear that Hitler isn't going to be that sort of big picture, let's think about the long-term health of our democracy kind of decision maker, right? Anne responds, "Your Honour, our position is that this work was not done lawfully, that it was unlawful, and that it needed to be a warrant, and that there needed to be a warrant, that this was done outside of a warrant." And the next bit is very important. "It's about an identification process. It needed to be a lawful process." Hitler then interjects, as he's wont to do. How is it a violation of his rights? And it's actually Hitler's next few sentences where we really get to the crux of the matter, and I genuinely hope that I do it justice and that you guys get it and that you see what I'm seeing. So Hitler continues, "I understand your position, which frankly is not well supported in the law. If hypothetically here, he went to this crime scene and committed these murders. If hypothetically here, he went to this crime scene and committed these murders." So it's actually really important that we nail down the chain of events here. We've got to use our power of reason to see how things should work and then expose exactly what's happening instead, okay? So the DNA is found. It's run through CODIS, but it doesn't yield any matches because the person on the other end of that has no criminal history. They have, as we were saying before, earned the right not to be in one of those dirty databases, okay? Remember, they are a clean skin. But what we are now confronted with in this new IGG landscape is unknown DNA that is now hypothetically guilty and in need of being proved innocent. And just like that, your presumption of innocence is no more, and you're left fighting for your life in a court of law about the ins and outs of DNA transfer, right? And Anne Taylor, in all her wisdom, broached that subject with Hitler, saying that it felt like burden shifting, which it is, and she was absolutely correct about that. It is burden shifting. And then he was kind enough to respond to her by essentially calling her position extreme. So, yeah, what I witnessed in that encounter was a judge feigning to have no wiggle room because there was no case law to suppress the IGG, when in actual fact he discreetly tiptoed around and covertly argued against the presumption of innocence. So disappointing doesn't even begin to cover how I feel about that exchange. It's almost treacherous, but this is why cameras in the courts are necessary. Yeah. So, yeah. Okay, so it's the prosecution's turn to get up to the lectern, and it comes in the form of Jeff Nye. And Hitler straight up asks, why should I permit evidence obtained potentially by searching databases that by its own policies, law enforcement said they wouldn't search? Mr. Nye responds, the individuals utilising these databases, and we are talking about millions of them, are willingly sharing their information with each other. Hitler doing his best or worst devil's advocate. But isn't there a subset that says, I don't want these people to look at it? And the FBI, as I understand the evidence, says, that's okay, we agree we won't search those ones. Nye. On the database piece, the issue is that no one sharing this information with millions of other people could have a reasonable expectation of privacy. The test for that isn't do they have a reasonable expectation of privacy against law enforcement. It's against the public writ large. It's against the public writ large. Well, sirs, the public writ large are nowhere to be found in those databases. It's the users of those databases that are aberrant. Okay? So your analogy, Mr. Nye, sucks. Plain and simple. So, we've had the defense, we've had the prosecution. So where are we now? Okay? No surprises, Hitler ruled against the IGG suppression. However, they're still trying to figure out how they can wangle it into proceedings. A few weeks ago, April 9, there was another open hearing, and I think they're called motions in limine or something. And it really is so telling how these people in the legal industry discuss really important, burgeoning social issues as though we're not right there listening to them. It's quite shocking. So Hitler introduces one of the 3 IGG motions like this. Let's talk about what I hope we have come to agree is not an issue, which is the IGG stuff. Talk about consciousness of guilt, right? Not an issue. Are you kidding me? Anyway, Ms. Biccabarlo steps up to the plate and announces, we have essentially, I think, an agreement with the state as to their position, and our position being equivalent at this point for different reasons, and that they will proceed with using the generic term or the generic evidence of a tip leading to the identification of Mr. Kohberger. Hitler adds, maybe you'd like to come up with some instruction to the jury that basically says, we're not going to tell you what that tip is and you don't need to consider it, or something like that. It's an invitation for you 2 sides to work together to try to solve this conundrum in a way that you both can live with. This conundrum. So I hope I'm not being inflammatory here, but it just seems to me that this insular circle of people in this little bubble of legal careerists are treating the public with utter contempt. And none more than Judge Hitler, you know? This is, and it is about Bryan Kohberger, but this isn't about Bryan Kohberger. This is about our future generations of people who we're about to sell down the river to the state by not ensuring that we protect them from government intrusion later on. Screw Bryan Kohberger, right? He might be guilty. This is the trial of the century, and don't let your better judgment be clouded for some base need of retribution. And on that note, let's not forget about Madison Mogan, Kaylee Gonsalves, Zana Kernerdle, and Ethan Chapin. Let's get this right. Let's get this right for them.